Hey, it's Guy DiMartino. Today I'd like to answer a question that somebody asked me just recently, and that is they were doing research regarding their estate plan, and they said, what is a spendthrift clause? What does it do? How does it work? Why would I want something like that in my estate planning documents? And I would like to answer that question for you because it seems that many folks might hear the term and not really understand what it is. So, a spendthrift clause is language typically within a trust document, whether it's a living trust or a testamentary trust, which attempts to protect funds that are going to a beneficiary from creditors. For instance, in my trust document, the language would be something like this. The interest of any beneficiary, either to income, which would be a monthly or yearly income, or the principal, which would be the property in the trust, in whole or part, shall not be alienated. What does alienated mean? Shall not be given to other people or transferred in any manner by the beneficiary, and such interest shall be exempt from execution, attachment, or legal process that may be started by a creditor. So there you have it. It is language attempting to protect the beneficiary from themselves. For instance, if they were in a business, they end up getting a collection action against them, they end up getting a judgment against them, and then they go and try to attack the money that's sitting in the trust for the beneficiary. Now, the language continues. This paragraph is intended to impose a spendthrift trust on all interest, on all stuff held for any beneficiary by the trustee. The rights of the beneficiary to withdraw trust property are personal and may not be exercised by a legal representative, attorney in fact, which would be a power of attorney, or others. It is our intent that the preceding spendthrift clause and the protections that it provides be considered a material purpose of this trust and any other trust that may be created under the trust. So what we're trying to do is we are trying to insulate the beneficiary from their own bad actions. One of the things that can defeat the spendthrift provision is if the beneficiary actually becomes the trustee. Because if the trustee or the beneficiary can access the money free and clear at any time that they will, that can be subject to creditors attaching it. So you need to have some other layer in there, like a co-trustee, and the beneficiary can't act on their own, or somebody else who is the trustee who actually doles out money for the health, maintenance, education, welfare of the beneficiary. So there are many ways that we can try to protect beneficiaries, and a spendthrift clause is one of them. If you have any questions regarding a Northwest Indiana estate planning matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.